Silence, court rise. Appeal in MS and Secretary of State for the Home Department.
Good morning, my lords.
Sorry we're slightly late, we had matters to discuss.
As you required. I appear with Mr Guillaume-Lewis on behalf of the Secretary of State, who's the appellant in this appeal, and my learned friends, Ms Charlotte Kilroy of Queen's Counsel and Ms Michelle Knorr, appear for the respondents.
It's likely, I haven't had a chance to discuss it with my colleagues on the bench here, but it's a rather warm day. If council would like to take off their wigs and gowns, I'm sure we have no objection. It's a matter for you. Some people prefer to brave it out, but if you want to, it's entirely up to you.
I think I may start by taking my wig off, certainly. Actually, and my gown. Thank you very much, that's very welcome. Look, could I just start with housekeeping to make sure we've all got the same papers and broadly in the same places? My lord should have two bundles of documents, a core bundle and a supplementary bundle. I don't think there have been any changes to those. Then there are two bundles of authorities. A main bundle that runs up to authority tab 33. And then a supplementary bundle, or the second volume of the bundle, which initially ran up to tab 46. We hope that you now have an additional tab 47 with the case of Zabala, which was recently provided to the court by my learned friends.
No. I've got this document here.
Yes, that's ours. I was going to come to that next. I don't know if my friends, I think we're going to need to deal with Zabala right now.
47 I haven't got.
But I'm sure we can make more copies available if they haven't reached the court. Our supplementary skeleton.
Have you got a bundle of respondents authorities?
Yes, is that a small bundle that arrived today?
It's not that small.
Well, I think about 6 tabs. Yes.
Not more than that, 17 tabs.
Ah.
Oh, I see what's that. No, this is it. Yes, 17 tabs.
I think that bundle was the authorities bundle from the permission application.
So
I'm not sure that that's the new bundle.
No, I don't think any of us are going to refer to the bundle from the permission application. That's been completely replaced by the new authority bundle, so that can be set to one side.
There's another bundle here.
My learned friend sent to the court today, and to us indeed.
I see, that's this one. Dublin reliant on Dublin 4.
Exactly, yes, that's right. And then there are some authorities appended to that. That's in response to us having provided to them on Friday a copy of Dublin 4, which we sent to the court yesterday, which I think is a document that my lord had at the outset. And I was going to suggest just adding that to the beginning of the respondents' bundle, replying to it. That seems a sensible place to have it, so all the Dublin 4 materials together.
Thank you. I hope you don't start construing Dublin 4.
No, I don't think so. We'd like to take you to one very short provision and 4 lines of the explanatory note, which we say is a matter to which the court can attach some weight, but it's self-explanatory, it's very plain on its face. So I think that's it in terms of housekeeping. The issues on the appeal, it seems to us that there are 4. The first of which is, should the court entertain this appeal at all? And you'll have seen the respondent's invitation that the court dismiss it summarily, effectively on the basis that it's academic, and that the CJEU wouldn't entertain a reference should this court consider that it's in real doubt about the outcome. Second issue, if the appeal proceeds, is ground 1. Does Dublin III confer a right to an effective remedy against the rejection of a take charge request? So that's the interpretation of Article 27 of Dublin III. And in order to look at that, we'd propose to take you through Dublin III itself, look briefly at a couple of the provisions of the implementing regulations, the relevant parts of the upper tribunal determination, which are very brief, and then we'll make submissions as to the language, the context, the purpose, and look at the relevant CJEU case law. Third issue, if we're right and Article 27 doesn't apply, does it make any difference? And you'll have seen the respondent's submission. It makes no difference at all because the approach on judicial review would be exactly the same. And then issue 4 is ground 2. So if we're wrong and Article 27 does apply, does it require fact-finding or oral evidence? So those are the 4 issues before the court. In terms of issue 1, should the court entertain this appeal at all, I hope, my lords, will have had a chance to see the respondent's skeleton where they address this at paragraphs 9 to 12.
Can I just slightly cut across, if I may, here? We've had an opportunity of discussing this, and we think that the logical and sensible way of dealing with this is for us to hear the other matters first, because it may be, at the end of the day, we find it is Act Clear, in which case the whole point falls away anyway. So we don't want to hear argument on that particular point at this stage.
Well, I'm so pleased, my lord, so that's exactly what I was about to invite you to do. And I've spoken to my learned friend, and she said she'd have no objection to that. She wasn't consenting, but really were in your hands. So that seems to us extremely sensible. So I'll move straight on to ground 1, if I may.
Thank you.
So, ground 1, the interpretation of Article 27 of Dublin III. You've got Dublin III at tab 1 of your authorities bundle. As my lords will be aware, at least some of the court will have looked at this before, this is the most recent in a series of instruments which are designed to allocate responsibility for determining an asylum application made to the member states. So it would be the responsibility of one member state to be decided in accordance now with Dublin III. The first of those instruments was the Dublin Convention, which was signed in 1990. But the immediate predecessor to Dublin III was Dublin II, to which Dublin III made a number of substantive changes. Those included, most materially for present purposes, the introduction of certain procedural rights, which we'll look at in detail. And then to complete the picture, the Commission published a proposal for a new and recast regulation, Dublin IV, in 2016. That includes proposals for new procedural rights. It hasn't been adopted. Indeed, the Dublin IV proposal has been the subject of some controversy amongst the member states. But we'll take you to it briefly in due course. Along with Dublin III, there are 2 implementing regulations, which you have at tabs 2 and 3 of your authorities bundles. Dublin III, helpfully, is a completely recast instrument, so it's self-contained and you can just read it and follow it through and understand it without any reference to its previous incarnations. It's not quite so straightforward with the implementing regulations, because the first implementing regulation, which you have at tab 2, was introduced at the time that Dublin II was in force. So a lot of its provisions refer to Dublin II, and the numbering of quite a lot of the provisions changed between Dublins 2 and 3. There's a table at the end which helps you reconcile them. And then the most recent implementing regulation, which is at tab 3, didn't recast the first implementing regulation. it simply amended it. So those two instruments, which I'm pleased to say we only need to go to very briefly, need some caution when you're looking at them, because where they refer to a provision, it's not always a provision of Dublin III. But I don't think either party wants to take you to very much of them, and we'll highlight very clearly where for Article 25 you now need to read Article 27. I hope the court will bear with me if I take a little bit of time over Dublin III, because it's quite important when we come to look at the meaning of Article 27 in context to understand the scheme of Dublin III and how it works. And I hope the court will bear with me, because I anticipate that some members are more familiar with the regulation than others. So I hope I don't try your patience too much by going fairly slowly at this stage. I promise I'll do my best to speed up afterwards. So can we turn to tab 1? There may be some other provisions that my learned friend wants to take you to in due course. I'm going to do my best to try and open this sort of fairly and in a balanced way, but I'm probably not going to be entirely comprehensive, so can I start with that caveat? So if we start with the recitals on the first page, you see the first recital at the bottom of the left-hand column, which is by the bottom hole punch, recites what I've just said to you, that Dublin III makes a number of substantive changes to Council Regulation EC 343 of 2003. That was Dublin II. At Regulations 2 to 4, recitals 2 to 4, you see that the regulation forms part of the Common European Asylum System, or is abbreviated as CEAS. And that the conclusions of the European Council at its special meeting in Tampere in 1999, which is referred to at Recital 3, stated, I'm moving on to Recital 4 now, that the CEAS should include, in the short term, a clear and workable method for determining the member state responsible for the examination of an asylum application. And that's what this instrument is designed to achieve. 5 is quite significant. Such a method should be based on objective, fair criteria, both for the member states and for the persons concerned. It should, in particular, make it possible to determine rapidly the member state responsible, so as to guarantee effective access to the procedures for granting international protection, and not to compromise the objective of the rapid processing of applications for international protection. So it's twofold. This is what this court has previously referred to as an initial procedural stage in an asylum application. It's not deciding the merits of the asylum claim, it's simply deciding which state should look at it. And that process should itself be undertaken rapidly, so that the subsequent substantive process itself can be determined rapidly. That's why you've got rapidly twice there. We can move on, for my purposes, I think, to Recital 13. That records that the best interests of the child should be a primary consideration when applying the regulation. Member states should in particular take due account of the minor's well-being and social development, safety and security considerations, and the views of the minor in accordance with age and maturity, including background. You'll see by the final sentence that in addition, specific procedural guarantees for unaccompanied minors should be laid down. We'll look at those briefly in due course. The specific guarantees to minors are in Article 6 of the substantive provisions of the regulation. Article 14 records the importance of respect for family life. And Article 15 again deals with dealing with members of one family by a single member state. 16 also. Recital 19, which is central to this ground. I won't read it out if you don't mind, but I'll invite the court to read it. So, in order to ensure that international law respects an effective remedy against such decisions should cover both the examination of the application of this regulation and of the legal and factual situation in the member state to which the applicant is transferred. And then finally, by Article 41, you'll see that the UK has opted into Dublin III, by contrast to our position on Dublin IV, where the current indication is that the UK doesn't intend to opt in. Then we turn to the substantive provisions. Just below that. Chapter 1 is self-explanatory. Article 1 is self-explanatory. Article 2 sets out a number of definitions. And can I draw attention to a couple of them at this stage? Firstly, you will see if you look at G and H that there's a distinction between family members and relatives. Family members include spouse or unmarried partner, where there's a stable relationship, and the minor children of such couples, as long as they're unmarried. And then at the next two bullet points, where the applicant's the minor and unmarried, father, mother, or another adult responsible, and the same where the beneficiary of international protection is a minor and unmarried. So it's to make sure that it covers the situation where the applicant is a parent and where the applicant is a child. It doesn't include siblings, but as we'll see when we come to it, the provision, the criteria for allocating responsibilities make express provision for siblings. Relative at H means the applicant's adult aunt or uncle or grandparent who's present in the territory of a member state. Minor means a third country national stateless person below the age of 18. And unaccompanied minor at J means a minor who arrives unaccompanied by an adult responsible for him or her for as long as he or she is not effectively taken into the care of such an adult. And it includes a minor who's left unaccompanied after entering the territory, so somebody who comes in with an adult who's responsible for them, but they're separated. Chapter 2 on the facing page sets out general principles and safeguards. And Article 3.1, which is really at the heart of it, member states should examine any application for international protection by a third country national or a stateless person who applies on the territory of any one of them, including at the border and transit zones. The application should be examined by a single member state, which should be the one which the criteria set out in Chapter 3 indicate is responsible. I think for our purposes it's only 3.1 we need to look at. Article 4 sets out the right to information. And as soon as an application for international protection is lodged, and we don't need to look at this, but it includes claims under Article 3 and subsidiary protection as well as asylum claims. But you often see the word asylum applicant or asylum claim used compendiously. But as soon as an application for international protection is lodged, the competent authorities shall inform the applicant of the application of this regulation, and in particular of, and what's significant here for our purposes is D, the possibility to challenge a transfer decision, and where applicable to apply for a suspension of the transfer. Over leaf, I think we can turn to Article 6. As I mentioned when we were looking at the recitals, Article 6 sets out the guarantees for minors. They include the appointment of a representative, an obligation to cooperate in assessing best interests. 4, the member state where the unaccompanied minor lodged an application for international protection is under a duty to take action to identify family members, siblings or relatives on the territory of the member states while protecting the best interests of the child. And at 5, you see there's reference to the implementing acts, including a standard form for the exchange of relevant information. So those are the specific procedural guarantees for minors. And again, for our purposes, what may be significant is not so much, well, not just what it includes, but what it doesn't include, because it doesn't include any right of review or appeal that's specific to minors. On the facing page, Chapter 3, you'll see the criteria are set out. And the way it operates, which you see under Article 7, is that there's a hierarchy of criteria. So you go through them in turn, and responsibility is allocated in accordance with the first in the list that applies. At 3, in view of the application of the criteria referred to in Articles 8, 10 and 16, which we'll come to in a moment, Member States shall take into consideration any available evidence regarding the presence on the territory of a Member State of family members, relatives or any other family relations of the applicant, on the condition that such evidence is produced before another Member State accepts the request to take charge or take back the person concerned, pursuant to Articles 22 and 25 respectively, and that the previous applications for international protection of the applicant haven't yet been subject to a first decision regarding the substance. So that's a general overall provision. Then the criteria start themselves with Article 8. Where the applicant's an unaccompanied minor, the Member State responsible should be that where a family member or a sibling of the unaccompanied minor is legally present. We've looked at family members, effectively parents or but this expressly includes siblings as well, provided it's in the best interests of the minor. And then it deals with married minors, which we don't need to trouble with for the moment. There's a distinction between Articles 8.1 and 8.2. 8.1 applies to family members and siblings. 8.2 applies to relatives, which you'll recall are aunts, uncles, grandparents. So where the applicant's an unaccompanied minor has a relative who's legally present in another member state, and where it's established that the relative can take care of him or her, that member state shall unite the minor with his or her relative and shall be the member state responsible, provided it's in the best interests of the minor. So both 8.1 and 8.2 have a best interest clause, unsurprisingly. 8.2 includes a provision that the relative should be able to take care of the child. By 3, where there are family members, siblings or relatives in more than one member state, best interest is decisive. Then at 4, in the absence of a family member, a sibling or a relative, as referred to in paragraphs 1 and 2, the member state responsible should be that where the unaccompanied minor has lodged his or her application for international protection, again, provided it's in the best interests of the minor. Can I pause there to say it doesn't arise directly on the facts of this particular case, but there had been some debate about the member state responsible being where the application was lodged, whether that should be the first member state or the member state where the applicant currently is, because he may have lodged in both. And the CJU's held, I think quite definitively now, that it should be where the minor is now to avoid repeated unnecessary transfers. Really common ground. Yeah. Then 5 and 6 deal with implementing acts. And I don't think we need to look at those in any detail. It's worth noting that Articles 9 and 10 deal with family members where the applicant's not a minor. So people can seek to be reunited with family members even if they're an adult. Or somebody can be transferred to a state, for example, where their partner or spouse is living. And Article 11, which again doesn't directly arise in this case, deals with a position where there are several family members and or minor married siblings submitting applications in the same member state simultaneously, and again it's about family unity and keeping people together. So they're determined in the member state which is responsible for taking charge of the largest number of them. Failing that, the member state where the criteria indicates responsible for examining the application of the oldest of them. So it's very detailed, very specific provisions.
And so far, all mandatory.
I beg your pardon, my lord?
So far, all mandatory. The responsible, the state who has to deal substantively with the application shall be the one identified in Dublin III.
Absolutely.
And then, for example, in 8.1, the member state responsible shall be where the sibling is. All mandatory.
Yes. I absolutely take that on board. Yes. I'm not suggesting in any way that it's discretionary.
No, may comes in later on, but it's
Yes.
it's
Here,
with this background.
Absolutely mandatory, yes. I don't think we need to go in detail to any of the other provisions, but you'll see that they include, going down the hierarchy, so if we're not dealing with an unaccompanied minor, or if there aren't family members, you look at matters such as which state issued a residence document, in which states, that's Article 12, Article 13, where did the person enter the territory of the state? So did they come in by boat to Greece, for example, before travelling through? Article 13.2, where the state of entry can't be held responsible, you examine whether the person has been living for a continuous period of at least 5 months in a member state, then that member state's responsible. Persons lived for periods of 5 months in several member states, the most recent one's responsible. I won't take you through them all, but you'll see visa waived entry, etc. Chapter 4 deals with dependent persons and discretionary clauses.
What is the basic rationale at this level, which, as you say, is pre-substantive decision making? What is the rationale for placing the substantive decision in the country where there's a family connection? Why does it make a difference to the quality of the substantive decision?
No, I don't think, well, it doesn't make any difference, I can't think, to the quality of the substantive decision, which may vary depending to the state and what its individual procedures are, but it's to respect the principle of family unity. And
Because I assume this is on the assumption that it's right and just, consistent with Article 8, presumably an equivalent in the EU Charter of Fundamental Freedoms. It's consistent that in the period while the decision is being made, the substantive decision, that members of the family should be kept together.
yes, yeah, absolutely. There is no dispute about that. The difficulty that arises is where there isn't agreement between the member states as to whether there is or is not.
I'm trying to translate into, as it were, ethical terms, these provisions, because, as I said, it's not suggested that one state rather than another is going to make a better decision at the end of the day as to whether there should be asylum. But I assume it's concentrating on the right of family members, particularly where there are minors, that during the period up to the making of that decision, which may take some time, that the family members should be kept together. So it's respecting, as it were, a substantive right to family life in that period leading up to it. That's right, isn't it?
Yes, it is, absolutely. And there's no dispute about that.
Is there a second reason? That's one, and that concerns the period whilst the substantive decision is being made. But is there a second reason that if asylum is granted, all family members will, as it were, be in the same country? That may matter less in the EU because of freedom of movement. But is that another reason, or is there only the reason my Lord's referred to?
I think it's only the reason that my Lord put to me, because of course all the states have their obligations under, for example, the Charter of Fundamental Rights and Article 8, that if an application is made, and I'm going to be moving on to that at a later point in my submissions, but if an application is made, which they are required to accept, once the asylum decision's been made, so say for example, it's not accepted at an earlier stage that a couple are married or that they're in a stable relationship, so the asylum claims are decided, one in England and one in France. If they're both granted and thereafter an application is made, either by the person in England to go to France, the person in France to go to England, each of the France and England respectively would have to entertain that application in full compliance with their obligations under Article 8, for example, in the Charter of Fundamental Rights. So the fact that it may not be possible to establish at the initial procedural stage whether the relationship is a genuine one, whether it's in a child's best interest to be transferred or not, doesn't mean it's the end of the road. It's not a once and for all decision. We're dealing only with where the person is while the asylum decision's made.
Right, but how can you explain to me, how does that issue in the context of Dublin III, as a procedural, as it were, provision leading up to the making of a substantive decision, how does that overlap with or marry up to Article 8 rights to to family life? So, leaving can an applicant who claims to be a family member of someone in another state, a minor whose parents or siblings are in another member state, can they bring proceedings under Article 8, either in the state in which they're in or in the state in which they claim as a family member?
Yeah.
Can they bring those proceedings at the same time as proceedings are pending in relation to the Dublin III and the granting of asylum?
Well, that's an issue that's been considered by this court in two decisions, really, ZT Syria and RSM, and you've got the subsequent one in the authorities bundle, which I'll go to in due course. But in essence, this court has held that the appropriate...
Court of Appeal, is it?
Court of Appeal, yes. That the appropriate way to resolve this is through the mechanisms in the Dublin Regulation at this initial procedural stage, except where there are particularly compelling circumstances which mean that the family members need to be reunited more urgently, so that an application under Article 8 can be made in parallel.
So, I'm sorry if I'm taking you out of the way, but since we're concentrating on this part...
No, it's important to understand.
In this particular case, there was evidence that the child here, MS, was suffering increasingly mental trauma, sometimes described as post-traumatic stress disorder, whatever it might be, because of the delay. One, because of the delay in determining claimant, and B, because he felt frustrated that his claim to be related to his brother in the United Kingdom was being rejected, and he couldn't have for whatever reason, he couldn't have a DNA test. Does that mean, from what you've said, that he could have brought proceedings here or in France, or both, under Article 8?
As a matter of theory and principle, yes, he could. In terms of the guidance of this court, it's been made very clear that the threshold is a really high one for a large number of reasons. So, taking one extreme of the sorts of circumstances that can arise, there's a case that's often referred to as the Syrian baby case. It wasn't the case that was litigated in the end before the courts, but it's been referred to as the epitome of a case where Article 8 will require urgent action. What happened in that case was that a mother was separated from her very small child, I think a toddler, as they were climbing onto a lorry in an attempt to cross to the UK. The mother ended up on the lorry, the child, the toddler, ended up left behind in France. The epitome of a case where you don't say, well, the French authorities ought to submit a take charge request, we'll then consider what had to be done was reunite the mother and baby. And in fact, what the Secretary of State did was sort of cobble together a procedure which doesn't really work under Dublin, but just to try and effectively get them back together, which was done. So that's an extreme example. In other cases, it really has got to be a high threshold, and the court will look at all sorts of things like, for example, what is the relationship? How young is the child? Is this a parent and a child who've been temporarily separated? There'll be other cases, and I don't wish in any way to minimise the facts of this case, but where you have a much older sibling and a 17-year-old who hasn't seen him for over a decade. And I'm not saying that's at the bottom of the scale, but I'm saying there are different points in the scale. And this court has been discouraging of applicants from trying to engage Article 8 at this preliminary stage during the Dublin process in parallel.
So the only authority, what is a domestic one, there's nothing at the, at the Luxembourg level or Strasbourg level, no matter?
No.
Nothing?
No. It's two constitutions of the court. May help if we bring along ZT Syria as well. Justice Beatson gave the leading judgment in ZT Syria, and in the subsequent case, which you do have, RSM, it was a court where Lady Justice Arden gave the leading judgment. There's a concurring judgment by Lord Justice Singh. Sorry, I was in the case, so I ought to recall who the third member of the court was, but there was no third substantive judgment. And I think it was Lord Justice Peter Jackson, in fact, it was. And it was interesting because, of course, with his background in family proceedings, he made the point, which I think is probably quite a forceful one, that it's very difficult for the courts, when confronted with the facts of one case, to understand how urgent that is compared to all of the others, and that prioritising one case almost inevitably means that other cases will go back further in the queue. But we'll look at RSM in due course. For present purposes, can I just say, I hope that's satisfactory, that it's possible, in parallel with Dublin III, to make a request for a more urgent transfer in reliance on Article 8, but it will be rare that the court considers that's justified.
Is that because Article 8 runs through Dublin III? The recitals make it clear that the right to family life is an integral part of the system. So,
Yes.
so as it were, the system should be able to deal with Article 8. In some cases, it just might not work, and those are the exceptional cases you've referred to.
Yes.
But generally speaking, Dublin III should be Article 8 compliant. Is that
Absolutely, yes. Yeah. I quite appreciate that the points that you're putting to me are points that militate in my friend's favour, and I completely understand that, and I'm not trying to minimise them in any way. I'm not suggesting that there's any element of discretion about it. The difficulty that arises is when there is no agreement between the member states as to whether Article 8 is engaged, or whether I think we ought to take them separately, really, whether the provisions of Dublin III mandate a transfer. Because Article 8 may be engaged, may not be engaged, so some take-charge requests won't involve Article 8 at all. There'll be a take-charge request on the basis that the person who's an adult has lived in the state that's requested, as we've seen now, for a period of 5 months. So it's wrong to regard a take-charge request as always involving Article 8 considerations. By no means is that correct. The two are quite separate. And yes, Dublin III is of course intended, and it's plain from the recitals really, to be compatible with Article 8.
Well, I mean, but that's quite important. That's why, in a sense, you said things that I didn't want to say directly, but I think it's helpful, if that is the way you'd like to put it, that Article 8 and Dublin III should be compatible.
Yes.
That's your position.
Yes. But that...
I understand, but they're separate. No, I've got
But they
that.
are
They're
separate.
separate, but they should be compatible.
They should be compatible.
Yes. Thank you.
There may be circumstances where Article 8 requires a decision outside of Dublin III, so where Dublin III does not enable itself an Article 8 compliant decision, such as in the Syrian baby case. So I'm not saying that that Dublin III it covers all Article 8.
It doesn't cover the entire field.
It doesn't cover the entire procedure. No. There will be cases that fall outside Dublin III, but it shouldn't require breaches of Article 8. It shouldn't occasion a breach. So you can go outside it when necessary in order to ensure compliance with Article 8.
I think I wouldn't be unfair when I say this, that there are two limbs, therefore, to what we've got to so far. Article 8, from your perspective, Article 8 and Dublin III are separate. They must, however, be compatible, but in an orderly and ideal world, you wouldn't have to resort to Article 8, because really Dublin III, although it doesn't in law cover the entire area, should, save in exceptional circumstances, cover the area. Is that fair enough?
I think that is fair, yes.
That also means, doesn't it, that Dublin III has to be construed as being compatible with Article 8.
Yes, but recognising that it isn't intended to comprehensively guarantee an Article 8 compliant result in every case. So, for example, in RSM, the court held that there may be circumstances where, even though Dublin III could potentially be engaged, there's a requirement to make a decision outside it, because simply going through Dublin III without more would not provide an Article 8 compliant result on the facts of the case. So it forms
So
part
that's why I
of...
was saying save in exceptional circumstances.
Yeah, exactly. Yes.
Thank you.
So, I think we've dealt with the discretionary clauses. Can I ask you to move on to chapter 5, overleaf? About a third of the way down the left-hand column, obligations of the member state responsible. So the member state responsible has certain obligations. The first is to take charge under the conditions laid down in Articles 21, 22 and 29, which we'll come to in a moment, of an applicant who's lodged an application in a different member state. Then take back under the conditions in Articles 23, 24, 25 and 29, an applicant whose application is under examination and who made an application in another member state, or who's on the territory of another member state without a residence document. 1C, again, a take-back provision, relates to a person who's withdrawn their application and then moves on to another member state. And D is a person whose substantive claim has been rejected and has moved on to another member state. So you'll see that Dublin covers a very wide range of circumstances. Chapter 6, which is important for our purposes, the procedures for taking charge and taking back. So Article 21, the process of determining the member state responsible should start as soon as an application for international protection is first lodged with a member state. Then we have a lot of technical provisions about what is lodging, which we don't need to be concerned with. Section 2, procedures for take charge requests at the very right-hand side of the opposite page. And these are important. Where a member state with which an application for international protection has been lodged considers that another member state is responsible for examining the application, it may, as quickly as possible, and in any event within 3 months of the date on which the application was lodged, within the meaning of 22, request that other member state to take charge of the applicant. Next sub-paragraph provides a shorter time limit where there's a Eurodac.
Sorry, just on that paragraph, because this apparently becomes not mandatory. But just breaking the Article 21(1) down a bit, where a member state with which an application for international protection has been lodged considers that another member state is responsible for examining the application. So there, the requesting state, let's say France,
Yes.
must consider that the United Kingdom is the responsible state,
Yes.
because it considers there's a brother here, for example.
For example.
Now, once we get to that stage, from France's point of view, the UK is going to be the responsible state because it considers there's a brother here. So where it says it may as quickly as possible submit a take charge request, that's must, isn't it? Really. It can't sensibly determine not to make a take charge request in those circumstances, can it?
Yes, it can. So, can I just give you 2 examples?
Yes, please. Yes.
So, for example, it may consider that there's a relative here, a brother here, but that the applicant, the minor, is really well settled in France, is thriving with foster parents. The brother is a brother he's never met, doesn't consider it's in best interests. I suppose if it doesn't consider in best interests, it's
Yes.
yeah.
So
it won't be responsible. But
it has to
yeah.
be satisfied that this individual satisfies all of the criteria,
Yes.
including in those circumstances
Yes.
best interests.
Yeah. Okay.
But once it's satisfied,
of that, in the case of a child, I think it must be must. Probably in the case of a family member as well. In the case of some of the other criteria we've looked at, like length of residence. Oh, sorry, can I pause there for a moment? No. I'm just trying to be careful not to be too absolute. I think this would probably fall within the best interest provision, but of course there's always the provision about legal and procedural and practical protections in the other state. So say, for example, the brother wasn't in the UK but was in Greece, where transfers have been suspended because reception conditions are appalling, etc., etc. I think in the case of a child that would fall under best interests, but it really does not generally follow as a rule that because you think another member state's responsible, you must make a take back or take charge request. Other examples where the 5 months residence criteria is fulfilled. The state where the person is physically present, where they make their asylum application, may consider that there are humanitarian reasons, for example, for allowing them to stay, rather than trying to transfer them back to Slovenia, where they previously spent 5 months. So I wouldn't accept that may in 21.1 really means must, although I accept that it may well mean must in some cases, particularly those involving children. Is that an
no, I
answer?
think that's very fair. So may doesn't mean definitely must, but in most cases it is going to happen. It's going to be required in most cases.
Yeah, in children or family member cases. Yes.
That's very helpful, thank you.
And one of the things I've been pondering in the course of preparing for this is what the approach of an applicant should be if, say for example, they're in France and France says we're just overwhelmed, we are not making take charge requests to the Netherlands at the moment, so don't worry, we'll just consider your application here. I don't think that would be covered by Article 27, but one would presume that Article 8, for example, gives domestic remedies in France.
Quite.
Yeah.
Whatever they might be. Yeah.
Whatever they might be. Yeah. I hope that's helpful. Certainly, the regulation itself, we would say, does not provide a specific procedural remedy in the case where a state simply decides not to make a take charge request.
No, but Dublin III is based on the premise that states will do what they should do. If they don't, then there should be a remedy in the state to require them to do what they must do under the regulation. They have to make a take charge request in certain circumstances.
I think I'd accept that, but the regulation is plainly permissive. It may be that other obligations impose a higher...
Yes.
So just so I can understand this. So if take a minor and a relative, if a minor is in France and they're satisfied that a parent or a sibling is in another member state, say the UK, and France decides for various reasons pursuant to the permissive requirements under 21.1 not to make a take charge request to the UK. I think the first point I'm saying is there's nothing under Dublin III itself which specifically confers a right on the child to challenge that decision. But a assuming they have the equivalent, well, there are two things. First of all, although there isn't such a right specifically under Dublin III, actually could we reverse it so it's the UK and France the other way around, because it's easier, because we have judicial review here. So assuming the child's here, parents in France, the UK decides not to go humanitarian, whatever reason it may be, but the child wishes to challenge that. There's nothing under Dublin III which enables them to do so, but I think you're saying certainly the child could, in appropriate circumstances, challenge that under Article 8 here. So that would be by way of judicial review of the decision not to transfer, not to make a request, and the judicial review is based on Article 8.
Yes.
That's the way it would work here.
Yes.
Right.
Would it be also based on Dublin 3 though? So you say outside Article 8, Dublin 3 requires states to do certain things, and it requires states, when it considers another state to be the responsible state, to make a transfer, to make a take charge request. If it doesn't make a take charge request, that's would here be a ground for judicial review, wouldn't it?
Could I think about that and come back?
I mean, it would probably be under Article 8 as well. But,
Yeah.
but
I certainly accept it was under Article 8.
Yeah.
I would, I don't want to give a hasty answer, which I then have to go back on.
But if it was going to be, I understand my own point, but presumably if that was right, and I can see the logic of saying, yes, they've got a judicial review, as it were, for the making of a decision by a public body directly under under Dublin 3, that presumably would be on rationality grounds. So it would be a narrower, the nature of the challenge would be a narrower one than Article 8, but it would still be an effective challenge. Does that sound right?
That does sound right. I think probably the argument would be that Dublin confers a power, and that power's got to be exercised compatibly with the rest of our obligations, I would have thought.
Yes. Right, thank you.
yeah.
But I would like to think about this and come back if
Yes,
there's more that I need to say.
Yes, of course.
You'll see by the third subparagraph of 21, what the consequences are if the request to take charge of an applicant is not made within the periods laid down in the first and second subparagraphs.
Sorry, could you repeat that?
Sorry. Where the request to take charge isn't made within the periods laid down in the first and second subparagraphs,
Yes.
so 3 months under the first subparagraph and 2 months if there's a Eurodac hit under the second subparagraph, and this is mandatory. Responsibility for examining the application for international protection shall lie with the member state with which the application was lodged, and that's not a may or it's absolute. So going back to the scenario that we posited, if you're looking at which is the responsible state and those are mandatory, this equally is mandatory, because part of the operation of Dublin is to ensure that time keeps moving. So it's balancing, in a way, the principles underpinning where a decision should be made with the principle that it's also really important that it's made quickly. And that ties into my other point, that it's of course possible to make an application for entry clearance after the protection decision's been made. And so you've got these competing factors, which is that it's important for asylum applicants or protection applicants to have their status resolved quickly. And that balances with the importance of getting it decided in the right state, if I can put it that way. So if, for example, it takes 18 months of litigation to sort out which is the right state, it might well be that within that period, the substantive claim could have been determined and an application to enter somewhere else could have been made under, for example, the refugee reunion policy. So this recognises it's all inherent in this being the initial procedural stage. And one of the reasons I was hesitant to give too absolute a reply to my Lord Justice Hickinbottom's question is because whilst I'm not suggesting judicial review is excluded, in exercising its discretion, the upper tribunal or the judicial review court will need to take that into account as well, the way the scheme works. So it shouldn't be making orders that are flatly inconsistent with Dublin III, and it should be taking into account matters such as delay and whether there is an equally effective alternative remedy on the facts of individual cases. I mean, these cases are all fact-specific, of course.
The example that you suggested, or that we've been discussing, is where, as I understand it, is where the state, the UK, as a policy says, we're simply not making take charge requests at all.
And that's completely hypothetical. I'm not aware of any situation where that's arisen, obviously.
But then as a policy, that could be challenged.
Challenged, of course it could.
But in an individual case, if the government simply didn't make a take charge request, wouldn't that paragraph then kick in after 3 months?
Yes, exactly.
And so whatever the individual wanted, the moment would have passed.
Precisely, yes. I'm sorry, I was putting it very clumsily. That's precisely the point I'm making. At that point, it wouldn't be the responsible state anymore. So it's pointless. Well, it would be contrary to the express language of Dublin III, for example.
Because the state in which the application had been made would be the responsible state,
it would be
as it were, full stop.
Yes. The reason I said I was going to take this quite slowly is because it really is a very complex regulation. What we did, we sort of went through the discretionary clauses very briefly because they don't really arise on the facts of this case, but I think it's probably important for the scenario that you've posited with me to just go back and look at Article 17. And it's 17.2 which might be relevant in that particular scenario. The member state in which an application for international protection is made and which is carrying out the process of determining the member state responsible, or the member state responsible. So the member state responsible would apply where responsibility is shifted because the time limits have passed, may at any time before a first decision regarding the substance is taken request another member state to take charge of an applicant in order to bring together any family relations, etc. So just seeing how that would work in practice in the example we're looking at. Can I take France as the state where the applicant is? Somebody makes an asylum application in France. Just on the individual case, for various reasons, the time elapses without a take charge request being made. France then becomes the responsible state because Article 21 is absolute. So the third subparagraph of Article 21 would kick in, where the request to take charge is not made within the periods laid down in the first and second subparagraphs. Responsibility for examining the application for international protection shall lie with the member state in which the application was lodged.
And I'm sure this is obvious, but that overrides everything. So this individual might have brothers and parents all over the place, or in another state, And that wouldn't matter.
No.
Article 21(1), that paragraph, as it were, trumps all of that.
Yes.
And the state in which the application was made has to get on with it.
Well, is the responsible state.
I'm sorry, is the responsible
Yes.
state.
Yeah, absolutely. But that state could make a request to the UK if it then discovered there was a brother here under 17.2, which is why I just took it to 17.2. So you can ignore sorry, my highlighter. The member state in which an application for international protection is made, on your hypothesis France, you can ignore the "and" which is carrying out the process of determining the member state response. So that clause can go. Or the member state responsible, which in that scenario would be France, because it had become responsible because the time limit had elapsed, may at any time before a first decision regarding the substance is taken, so before it's actually determined the asylum claim, it can request another member state to take charge. Even where that other member state is not responsible, under the criteria laid down in 8 to 11 and 16, the persons concerned must express their consent in writing. There's a point against me, but I think it's right to bring to your attention.
In a case, and this may be that the facts of this case may be the correct ones. So in a case where there is an ongoing investigation and debate between two states as to whether or not there is a sibling or parent in the other state, and the 3 months has passed, there still remains a purpose in pursuing those inquiries, because if the interests of the child are paramount, generally, then that would be a good reason for the responsible state, France, to make a request under Article 17.2. And it would be no response to that for the UK to say, well, we're just not going to accept it, even if it's satisfied that there was a family connection, and that was proven. That could be challenged.
It's a very wide discretion, the courts have said, under 17.2, but certainly
It's a wide discretion on the state to make the request, but there's also, there's a concomitant, I would suggest, I'm asking you, there must be a concomitant responsibility under all of those international provisions making the interest of the child paramount, as well as Article 8, for the recipient, the state receiving the request, not to simply say, well, we don't, once the 3 months has passed, that's it, it's too late. They have to consider it on its merits.
Yes, absolutely.
So it's not as though, and I'm grateful, it's not as though the 3 months or the 2 months under Article 21 ends everything.
No, that's why I wanted to draw your attention to 17.2. Yeah,
That's helpful.
What does end everything, even on 17.2, is a first decision on the substantive asylum claim. And it's probably worth you knowing for these purposes that although we, the UK, hasn't opted into the Procedures Directive, France and pretty much every other member state has, and they're under an obligation to decide a substantive asylum claim within 6 months. And we'll go to it if we need to, but time ticks from the time the application's lodged.
This is under your first and second regulation. This is under the implementation regulations.
No, it's not. It's under the... Remember we looked at the recitals, the Common European Asylum System?
Yes.
That includes a number of instruments. So Dublin III is concerned with the initial procedural stage, but then there's a procedures directive and a qualification directive. We've opted out of the 2013 procedures directive, but it requires, save in certain quite constrained circumstances, that asylum decisions should be made within 6 months. I think it can be extended by 3 months in certain circumstances. So all of these instruments need to be read compatibly and consistently with each other.
We've opted out of that,
Yeah.
or we haven't opted in.
Don't know which way. We're not in it anyway. We're bound by the earlier procedures directive, but not the recast 2013. I think. Check that's right, isn't it? Mr. Lewis, who's my go-to person for this, tells me I've got that right.
Right. Okay. Thank you.
So that's Article 21. Provision for urgent replies, standard forms, I don't think we need to go to. Article 22, replying to a take charge request. Sorry, that's replying. Article 21, submitting a take charge request. Article 22 is replying to a take charge request. So the requested member state, and it's good to bear the language in mind when we get to the CJEU case law. The requesting member state is the state where the application is made. They request another member state to accept responsibility. They're the requesting state. And the state that receives the take charge request, or in take-back case of the take-back request, is the requested member state. The requested member state shall make the necessary checks and shall give a decision on the request within 2 months of receipt of the request. And then again, there's provision for evidence, implementing acts, etc. And again, there's a provision for automatic consequences where the time limits aren't met. If you look at the last subparagraph of Article 22, Article 22.7, failure to act within the 2-month period mentioned in paragraph 1 and the 1-month period in paragraph 6, which is we don't need to worry about that, that's in certain circumstances the time for applying is shorter. Failure to act in the 2-month period mentioned shall be tantamount to accepting the request and entail the obligation to take charge of the person, including the obligation to provide for proper arrangements for arrival. So it's what's often referred to as deemed acceptance. I don't think we need to go to them in detail, but Articles 23 and 24...
So on Article 22, but you may be dealing with this later, it refers to the procedures or the evidence that you look at in responding to a take charge request, which is in the implementation regulation.
Yes.
Are you going to come to that?
I was going to go to it briefly, the lists of probative and circumstantial.
Because the lists are, of course, related to both the requesting state and the requested state.
Yes.
The list in respect of the requested state refers to a limited number of issues.
Yeah.
But if you come to that, that's fine.
I mean, maybe you've got questions in respect to that I hadn't thought of and I don't have an answer prepared for, but when we look at it, you can tell me if there's anything else I can help with, and I will try and think about it and hopefully give the right answer. So that's 22.7. I don't think we need to look at take-back requests because substantially the procedure mirrors it and we're not concerned in this case with a take-back request. But again, you've got provisions for the submission of the request, the reply to the request, and a set of mandatory time limits where non-compliance results in responsibility shifting. Key to the present case, to ground 1, is section 4, headed procedural safeguards. Article 26 is headed notification of a transfer decision. You'll see that it applies by 26.1 where the requested member state accepts to take charge or take back of an applicant. Sorry, accepts to take charge of or take back an applicant or other person is referred to in 18.1c or d, and you'll remember those are people who've withdrawn their applications or the applications have been rejected. So that we can just ignore the or other person referred to in 18.1c or d. It's really just referred to compendiously, I think, as applicants for simplicity. Where the requesting member state accepts to take charge of or take back an applicant, the requesting member state shall notify the person concerned of the decision to transfer him or her to the member state responsible, and where applicable of not examining his or her application for international protection. They've got a legal representative. Member states can notify the decision to that legal advisor instead. So where Article 26 refers to a transfer decision.
What are those words referring to, or of not examining his or her application? What situation is that referring to?
It's referring to the situation where the person, the usual situation where the person has applied for asylum, for example, in France. France decides that Germany is responsible. It won't examine the application for asylum. It will simply refer the person, or ask Germany to take responsibility. If Germany takes responsibility, the person will be transferred, and the asylum application will not be considered in France.
Thank you.
I think the where applicable is only there to cover the situation where the asylum claim has already been refused. But I'll check and come back to you on that if I may.
They seem a bit redundant. If the explanation
It does seem a bit...
it's that they seem to be redundant words.
Yeah.
Anyway. Yes.
Yeah, I agree. They seem redundant to me, but I'm sure there's an explanation, and I'll try and identify it. I don't think it much turns on it for our purposes. But anyway, so where there's an acceptance of a take charge or take back request, the question member state notifies the person concerned of the decision to transfer. And that decision, the notification decision, includes information on the legal remedies available, including on the right to apply for suspensive effect, where applicable, time limits, etc. Second subparagraph of 2, information about legal assistance. And again at 3, where the person's not assisted or represented, the person's got to be informed of the main elements of the decision, information on the legal remedies available, and the time limits applicable for seeking such remedies. Article 27, headed Remedies. The applicant or another person, as referred to in 18(1)(c) or D, so the person who's within the take-back provisions, C and D, shall have the right to an effective remedy in the form of an appeal or a review, in fact and in law, against a transfer decision before a court or tribunal. (27)(2), member states should provide for a reasonable period of time for that to be exercised. And I'm not going to take you through in detail 3 to 6, but 3 is important because it requires the member states to make provision in national law that the appeal or review confers upon the person concerned the right to remain in the member state pending the outcome, or the transfer is automatically suspended for a certain reasonable period of time, during which a court or tribunal, after a close and rigorous scrutiny, will have decided whether to grant suspensive effect, or C, the person has the opportunity to request suspension. And it's at C, the opportunity to request within a reasonable period of time a court or tribunal to suspend the implementation of the transfer decision pending the outcome of the appeal or review. And there are rights to legal assistance and, where necessary, linguistic assistance. And a right to challenge a refusal of free legal assistance, etc. So very detailed procedural provisions in Article 27. I don't think we need to look at Article 28. Article 29 deals with transfers. At 18.1 you'll see the transfer of the applicant from the requesting member state to the member state responsible should be carried out in accordance with the national law of the requesting member state after consultation as soon as practically possible and at the latest within 6 months of acceptance of the request, or of the final decision on an appeal or review where there's suspensive effect in accordance with 27.3. So again, detailed provision for the consequences of the exercise of an Article 27 remedy and time starts to run for the transfer to take place from the date of the final decision on an appeal or review. And then again, as with the other provisions we've looked at...
Can I just ask you this? Section 3 deals with procedures for take-back requests.
I'm sorry, where's my lord looking at?
Article 23?
Article 23, yes.
Yeah, section 3, under section 3. I'm sorry, I did a bit slow about this, excuse me.
Yep.
Where a take-back request is accepted, where are the provisions for challenging that?
You can't challenge the acceptance of the take-back request. You have to challenge the transfer, which will take effect.
Yeah, I understand that. So the point I'm trying to make is, right, I see. So Article 26.1 is dealing with acceptance of a take charge or a take back.
Take back,
I see,
yes.
both of those.
Yeah.
So it's dealing with both of those.
Yes.
And you're about to transfer, then you have to notify them of the decision to transfer. So Article 26 covers both.
Yes.
Right. Okay, thank you.
I understand the point you make in your submissions that decision to transfer is not the same as a decision to transfer is not the same as an acceptance of a take charge request. I understand that as a concept, but in fact Article 26 makes this clear, doesn't it? And indeed Article 29.1 that you have a take charge request, and if and when it's accepted, you have a transfer decision. Conceptually, they may or may not be the same thing, but you have a transfer decision because that is the thing that has to be notified, and that triggers the time under 29.1.
Yeah. If the request is accepted, the requesting member state, so not the state that's accepted the request, but the requesting, the person who made the state who made the request, has to notify the person concerned of the decision to transfer.
I know you put weight on that too. At the moment, I'm not convinced that a decision to transfer is the same as notifying a decision to transfer. But leaving that point aside for the moment, take charge request plus acceptance. At the moment of the acceptance, you have a transfer decision.
No, I wouldn't agree. I'm sorry, Mahmood, I wouldn't agree. Say, for example, the request is made to Greece. Greece accepts the request. In the meantime, conditions in Greece have become so poor that there's a decision that we're not going to transfer back to Greece. It would breach our obligations because this is a real situation that arose. That's why I give it. The reception conditions are so poor in Greece that even if Greece is accepted, we will not transfer. There's no transfer decision. It doesn't follow automatically as night follows day, and the acceptance and the decision to transfer are not one and the same.
Even looking at 26, which says where the requested member state accepts to take charge, which is what we're concerned with, of the applicant, the requesting member state shall notify the person concerned of the decision to transfer him. You say that between the acceptance of the take charge request, the requesting state has to take another decision, a decision to transfer.
Yes. Yes.
I mean, that sounds theoretical. That sounds quite theoretical. Why would they make a request in the first place if they don't intend to transfer?
Well, they probably do intend to transfer at the time they made the request, but circumstances can change. And so there obviously has to be a second decision because it's the state where the person is present who has to initiate the transfer. And we'll see that in a moment.
I mean, if that was going to happen, then they'd withdraw. I'm just trying to be practical for the moment. And if that really was a situation, surely they just write to the requested state and say, well, look, we no longer want to transfer to you. We withdraw our request. They wouldn't wait, would they, until the very moment of the acceptance of the request and then say, well, we've changed our mind now. I mean, that seems a bit impractical.
It may seem impractical. When we go to the CJEU case law, I'll try and show you that the court has said that the acceptance of the request is an anterior stage to the transfer decision, and that the challenge is to the transfer decision, not the acceptance of the request. So, if I'm wrong about this, at least I'm in good company.
But you say it's more than conceptual, as I understand your submission, because in a case where a requesting state genuinely thought that the criteria were satisfied, that the responsible state was another state, Greece, and consequently sent a take charge request, Greece says, yes, we'll accept this individual. Between that and the transfer decision, the requesting state may reconsider the lawfulness of sending somebody to Greece. Is that what you say? As a practical matter?
It's just an example, but yes. Or the person at the time that they're yes. I mean, yes. And the reason it's important is because, as we'll see from all the CJEU case law, what is challenged is the decision to transfer by the state where the person is physically present. People aren't bringing under Article 27 legal proceedings against the requested state. So the person in France who a decision is made to transfer them to Greece, the request has been made, Greece has accepted responsibility, and France notifies the person it's going to transfer. And the appeal, whether it's JR or whatever other remedy, is against France for transferring. They don't have an appeal against Greece saying you shouldn't have accepted or your reception conditions aren't good enough. What they say is, I am here in France and France should not be transferring me, either because the criteria aren't made out or because Greece isn't safe. But that's where the remedy lies. And that's the scheme that the regulation has set up. The appeal is against the transfer not against the acceptance.
I understand that, and that is a related point to the one I made. But as I say, there is a separate point, I think, and that is, you say it's not simply conceptual, because something may happen. Something may have happened between the take charge request, or even after the acceptance of the take charge request, before the decision to transfer, which could mean that the requesting state says we're not making a decision to transfer.
Yes. Yeah.
And you say, in response to my Lord's point, that the proper response to that is not withdrawing the take charge request, because that's all dealt with, it's been accepted, but it's actually not to make a decision to transfer.
Yeah, I mean, I don't think that's something where the regulation's prescriptive, but I will double check in the implementing regulations, for example, which are all very complicated. I think it's probably up to the state whether it decides to withdraw the request, although if it's already been accepted, it probably just, quite frankly, sends a courtesy letter to Greece saying we're not proceeding with the transfer, and then gets on with deciding the substantive asylum claim. I mean, I'll take instructions, I'm sure, as to what we do, but there's generally quite a good level of communication and cooperation and between the Dublin units in the different countries.
And you make that submission despite the fact that 29.1 time starts to run from the acceptance of the request,
Yes.
not from the decision to transfer.
Yeah. Once the request has been accepted, the requesting state has got 6 months to effect the transfer. So the transfer is something different to the acceptance. And by 29.2 at the bottom of the left-hand side of that page, you see again another deeming provision where the transfer does not take place within the 6 months time limit. The members. I'm so sorry, my lord. I'm still on Article 29.
Yes.
29.2, which is at the bottom of the page, where the transfer does not take place. Does my lord have that? So if the transfer doesn't take place within 6 months of the acceptance, then again responsibility is transferred to the requesting member state.
But again, there is a difference between a transfer decision and a transfer.
I agree.
And the time here for the transfer is triggered not by a decision to transfer, but by acceptance of a take charge request.
Yeah.
There may be nothing wrong with that. That's how it is.
Yes, I think it's trying to provide certainty, but because you're dealing here obviously with a situation where it's not just the state and an individual, it's two states and individuals, so it's almost a triangulation of trying to make sure there's certainty for everyone.
But you say in that 6 months, the requesting state has to do two things. One, take a decision to transfer, you say, and two, actually transfer the individual to the second state.
And I accept that in practice, in the vast majority of cases, as soon as there's an acceptance, it'll be implicit that there will be a decision to transfer, and they'll then start communicating about the arrangements for transfer. And it's for the requesting state to initiate the discussions about when transfer should take place, where it'll be to. So will it be by boat from Calais to Dover? Will it be by plane from Athens to Manchester? Where is this person going to be accommodated? And they will liaise about it. But the decision in principle to transfer would almost inevitably be made, almost invariably be made, pretty much on as soon as the acceptance is received. So the acceptance will be received and the state will inform the person under 26.1, we've received an acceptance and we will be transferring it.
slightly troubled, it may get nowhere, but what slightly troubles me, am I right in thinking that if the process is a request for transfer, an acceptance of the transfer, inactivity, through inefficiency, whatever it may be, on the part of the transferring state, so that no decision is, so no transfer itself takes place within the 6 months. There is no transfer. Because there's no transfer, there's no capacity of the applicant for asylum to challenge that, to challenge any conduct on the part of the transferring state.
Not under Dublin III itself, no.
That seems right. But you said, so what would the challenge be under then? How would the challenge come to that?
Domestic law, I accept, may provide more generous remedies than Dublin III provides, but you've got to be really careful about them, because Dublin III is premised on keeping the clock ticking and moving out of the procedural stage to the substantive stage, where somebody is actually determining the asylum claim, because that's what this is really all about. That's why we looked at the recitals. It's about getting people effective access into the substantive.
Well, I appreciate this, but this would be a case where the applicant would be saying, get on with it.
Yeah.
But he or she can't say get on with it because there's no remedy on your interpretation.
Well, what often happens, I mean, in very, very many cases, applicants do not want to be transferred. So you'll see when we look at the CJEU cases that a lot of them are cases where people have said the time limit expires. You know, it's too late for Germany to try and transfer me.
No, I appreciate that, but we should be looking at the cases where they do want to transfer.
Yes.
I don't think it's helpful to look at a case where they don't want to transfer. And I think where we've got to on this now is that even where there's been an acceptance of a request, and even where the applicant wants the transfer, for example, he wants to have as a child, this is all subject to Article 17, I think, the discretion of the law. There is no remedy except for a domestic remedy, if it exists, for the applicant to compel the requesting state to effect the transfer. There's no remedy there.
And I'm sort of leaping all over the place in the scheme of my submissions, but I think it would be no, absolutely, that wasn't meant as a complaint, because it may be helpful to deal with this now. I was going to cover this when I came to develop my submissions. It may be significant to look at the evolution of Dublin. So under the Dublin Convention, it was the case and was held by the CJEU and by the domestic courts that the convention was not intended to confer rights on individuals at all. And so there are decisions up to and including at the level of this court saying an individual applicant can't come here and complain that the responsibility criteria have been wrongly applied.
It was purely a mechanism, an interstate mechanism for determining who was going to be responsible for an application, to ensure rapid determination, and also to ensure that there weren't multiple applications, which before then there were.
Absolutely, yes. Yes, my Lord puts it far more clearly and succinctly than I was probably. What we say happened with Dublin III is that a limited right of individual remedy was conferred. And it was conferred in circumstances where the state, whichever state it was, wanted to remove the person from the place where he had arrived under his own steam, so to speak. So in deciding what remedies to confer, Dublin III didn't draw a distinction between adults and children, or take charge or take back, family members or non-family cases. Where it drew the line was status quo or removal. Transfer, as they would call removal. So you've got a right in the regulation to challenge a transfer if you do not want to be transferred. What the regulation doesn't do is give you a right to require another member state to admit you, not under Dublin III. And in a way, one sees the sense of that because it's always open to applicants to make, as I said, once the asylum claim has been determined, they can apply to wherever they feel they want to go, or indeed have a right to go, to live permanently. But in removing somebody and transferring them against their will, you are changing the status quo and you're putting them somewhere they don't want to be. And generally, states give more extensive remedies against a sort of act of forcible removal than against what is essentially an argument that I should be transferred more quickly, or I should be transferred now at the procedural stage. I shouldn't be made to wait. And as I say, in my submission, this court has said that the gap is filled in a compelling case by saying that Article 8 requires more than Dublin III requires. And I entirely accept that. I wouldn't argue against it. I mean, in any way. But that's where the dividing lies. Right?
So basically, the framework that you're putting to us, standing back from the whole thing, the framework you're putting to us is that there was a clear intention in Dublin III to depart from Dublin II in at least one very important respect, namely for the first time in conferring rights on individuals, which previously didn't exist under Dublin II.
Yes.
But in doing so, a decision was made only to confer rights to challenge decisions to transfer from one place to another, but not to enable any decision to be challenged which resulted in the non-removal. But that, nonetheless, there were situations in which that can be challenged, including under Article 8. And so that in that respect, there is not an overlap and a coincidence between Article 8 and Dublin II. That's standing back from that's your whole case, and that therefore recital 19, which does not refer, as does Article 26.1 and Article 27.1, to a decision to transfer, or a transfer decision. It talks about in respect of decisions that nonetheless has to be interpreted in the light of the language of Article 26 and 27.
Yeah.
That's the overall framework.
Yes, exactly. So Article 19 is, Recital 19 talks about an effective remedy in respect of decisions regarding transfers. Again, but it's regarding, it is...
It's we're to regard that as a decision to transfer.
Yes.
That's what we have to regard. So that's what it comes to.
Yes. When you look at the actual substantive articles, in my respectful submission, it's the only way of making sense of them.
I mean, we in a sense, we don't have to construe the recitals in the light of the substantive provisions. It's whether the recitals help us in construing the substantive provisions.
Yes.
Where I find this this argument, which is an argument of construction, difficult, we obviously have to construe the words in the full European context. I understand that, but historically, and one suspects why the individual rights were brought in, is that people landed in Mediterranean countries where they may not have wanted to go back to, possibly for good reason because of Article 3, so when northern European states, including the United Kingdom, who generally speaking probably would prefer another state to deal with an asylum application rather than them if they can. When they sent a request to one of those Mediterranean states and got a positive answer back, it was important that the individual had a right to say, I do not want to go there for Article 3 or some other reason. So that's a sort of historical background. But here we've got a different situation where almost the roles are sort of reversed. So we look at something like Article 27.3, and that's clearly targeted to positive decisions to transfer, not negative decisions to transfer. But we still have to construe this, we still have to consider whether this was intended to deal with negative decisions to transfer. And you say, looked at fully and properly, that is not the intention of Dublin III.
That's precisely right. And I'm sorry, because as I said at the outset, my original intention had been to try and take you through the regulation fairly neutrally, but it's almost impossible because the questions are obvious, and if the questions are addressed, I can only address them on the basis of what our submissions are. So I hope Milan and friends are not too upset about the fact that it's not been a neutral taking you through Dublin 3, and she may well want to go back to it and tell you it means something completely different. And obviously that's her right.
But what is interesting about the submission you're making is that you don't say it's an oversight, you say it's a conscious policy decision.
Yes.
But you haven't got anything, as you were, is there any, what I would describe as extra regulatory commentary which supports you on that issue, that there was a conscious policy decision not to confer rights where there's a refusal to transfer, where the applicant wants one?
Well, I'm back onto my submissions, but I'm going to say, look at the plain words of Article 27. You've got to read it in the context of Article 26, which tells you what a transfer decision is. You've got to look at the operation of Dublin 3 as a whole, because what it does is provide for the clock to stop and everything be held and suspended so that things can be workable when there's a challenge against a transfer decision. It doesn't provide any mechanisms to cater for the situation.
That wasn't my question.
Well, sorry.
My question is there anything outside the words of the regulation itself, either preceding it or any other commentary by some reputable source, which points to a policy decision? I'm not expecting that there is or there isn't, but I'm just asking if there is anything.
Well, it's one of the reasons why I thought when I identified it that Dublin 4 might help you, because I don't know if you've had a chance to look at it, but the Commission's proposing a new remedy to give a right to challenge a non-transfer decision in family cases, which seems to me to be a pretty good clue that, at least in the Commission's view, it doesn't exist already. And unlike giving a broad power or a broad right to challenge any refusal or rejection of a take charge or take back request, it has geared it precisely to the circumstances of cases like these. So it's limited it. Because one of the problems with interpreting Article 27 as covering decisions not to transfer, as well as transfer decisions, it goes way beyond family cases. One of the problems. So, should we just look at that very briefly now? I suggested, as you may recall, that we add...
Have we finished now with the regulation? Dublin 2? Dublin 3, rather? Dublin 3? Why don't we finish?
Should we finish with Dublin 3?
Why don't we finish with Dublin 3 and then take
I'm sorry, that's very sensible. And Dublin 3 and then briefly Dublin 4 should take us to lunchtime, I think. So Dublin 3, go back to my speaking note, we've got to Article 29. So 29.3 provides for what should happen if the transfer is overturned on appeal or review after it's been carried out. And then it provides for the implementing acts, establishing uniform conditions for consultation, exchange of information in a whole range of circumstances for transfers. The only other provision of Dublin III itself, as opposed to the implementing regulations, that I was going to take you to is Article 37. That provides for a conciliation procedure between the member states. Where they can't resolve by agreement any matter related to the application of this regulation.
I'm not familiar with how this works in practice, but in a case perhaps such as this one, where France considers that an individual, the responsible state in respect of an individual is the United Kingdom because there's a brother there, and the United Kingdom looks at it and says no, he's not a brother. That's a dispute on any matter related to the application of the regulation. So that would fall, it seems to me, at least on the face of it, within the conciliation provision. And under the conciliation provision, I think, the result of the conciliation is not formally binding on the states, but is pretty persuasive. Is that fair?
Yes, I think that's the intention, and you'll see the last subparagraph of 2, whether it's adopted or rejected by the parties, the solution proposed should be final and irrevocable. I take you to this just actually as a matter of interest, because when I was reading the explanatory notes to Dublin IV, I discovered, rather to my horror, that the conciliation procedure has never been used, or certainly hadn't at the time of the explanatory notes. So I thought you should know it was there, but I thought I should also tell you that it's not something that the states, at least back in 2016, had ever availed themselves of, and I've not had time to check whether they have since. So it's a shame, but there we are. What is more often used is the procedure provided for in the implementing regulation.
Can I just raise a question on this? Deal with it later if it's more convenient and more sensible. So in the circumstance of this case, where France say it's the UK and the UK say it's not because he's not a brother, there is a dispute which apparently falls within the scope of this, of Article 37. France then may do a number of things. Firstly, it may say, well, okay, we've looked at the evidence again and we agree it's not, he's not a brother.
Yeah.
In which case the individual may have some form of relief in France. It may send the matter off to conciliation under this, at least theoretically, although apparently it's never been done. And if the conciliation result was, as it were, yes, they are brothers, then at least France would be under a lot of pressure to transfer.
And the UK would be under a lot of pressure to accept.
Yes, but also that there may then be relief available to the individual in France in respect of
yes.
that.
Yeah.
Or, as apparently happened here, France might, as it were, not do anything or not disclose their hand. But I was just wondering whether there was really a remedy in France under all possible circumstances. I'm not convinced there is, but in many circumstances there will be rights in France, which must be primarily responsible. That's where this individual is.
Absolutely. There's one additional option to the 3 that you've outlined, which is the option actually I'm going to go to next, as it happens, in the implementing regulation, because France has the option to renew a request where it's turned down.
Yes.
Once, and within very strict time limits, but it can include further information there, and you'll have seen that the state who rejects a take charge request has got to provide a proper explanation of why they have done that. And if the state that made the request thinks, well, you've just got the wrong end of the stick, or I have got further information which explains some of the matters that have caused you to reject it, then they should, their first port of call should be to renew their request with the additional information.
I understand, and as you say, there are provisions for that. But if, as here, the result of the review, they send further evidence, and the UK still says no, I mean, in practice, because of French domestic law, as I understand it, France can't send DNA evidence to the UK. So that's that. But in those circumstances, no right to any relief in France.
It's a matter for French domestic law. I mean, my experience, and I wasn't involved in this case at all at first instance, but in the one or two cases where I have been, in fact in RSM, and in one other case where I have been, the child has had quite active social workers abroad and legal representatives here who can be expected to investigate what remedies are available in the other country. Of course, an application for entry clearance, I'm sorry to go back to this, but can be made to the UK. And it seems to me that an obvious way of proceeding is to say to France, just please get on with determining the substantive asylum claim as quickly as you can, because I want to apply to join my family in the UK. And in a particularly compelling case, that application can be made even while the Dublin processes are running, where it's sufficiently compelling for the court to intervene.
So what you say, whatever the options are, we've gone through some. The individual should look to the rights, remedies and relief in the country that he is in this case France, whatever they may be.
Yes. Although, you know, in fairness to my learned friends, there's little that France can do to compel the UK to accept take charge request, and not putting in their merits, apart from the conciliation procedure, which, as we've seen, isn't utilised very much. Which is why, you know, sorry, I'm not going to say it again, but my real answer is we are looking with a temporary situation if it's urgent, Article 8 may require something to be done sooner, but generally what should be done is follow Dublin, use the Dublin mechanisms, and when Dublin says the matter is closed, responsibility now rests with France, or Germany or the Netherlands, what should be done is that they should make a swift decision, and then entry clearance applications can be made in the usual way. There's been no change in the status quo. The worst that happens in a delay case is a wait, more of a wait. But you'll have seen that on the facts of the present case, it was a year between the take charge request and the determination of the proceedings in the upper tribunal. So it's not that judicial review or exercising a cross-border remedy in the UK necessarily leads to a swift resolution. And I'll get back to that when I get to my second issue. Should the court be considering JR just as a, well, if Article 1227 doesn't apply, it makes no difference, we'll intervene anyway. You've just got to be a little bit cautious about it, particularly where the obligations of another sovereign state are concerned, because France or Italy or Germany or whoever still has their own, they've got an asylum seeker on their territory, and they have their own obligations to decide that asylum claim, to interview, to go, it's... So one just needs to be a little cautious. Should I go to the implementing regulation first or to Dublin 4 first? What would help the court most?
Well, it's entirely up to you.
I'll go to the implementing regulation first, as we're there. It can be dealt with quite briefly. So tab 2 is the 2003 one, which, as I say, was amended but not recast in 2013.
So just the explanatory notes, this really relates to the question asked before, the explanatory notes to Dublin III said nothing about the issue we're now concerned about, that is, whether or not there's a right to challenge or no right to challenge a decision not to transfer.
Do you know, sorry, I'm not sure there is an explanatory note to Dublin 3 itself. The explanatory note that we've got is the explanatory note that goes with the Commission proposal for Dublin 4. I will check, or I'll ask Mr Lewis to check over lunchtime, if there was, and I'm so sorry it didn't occur to me, but of course I should have done this sooner, to check whether there was an explanatory note that went with the proposal for Dublin 3. Yeah, absolutely.
Right.
I'm so sorry, I've got a terribly dry mouth. Could I possibly just try and get some water? So, sorry, tab 2 is the first implementing regulation. Regulation 1560 of 2003. And it's Article 5. Which is, well, should we start with Article 3 in fact? Reaction to requests, Article 3. The arguments in law and in fact set out in the request shall be examined in the light of the provisions of Dublin 2, because this is what this refers to, and the lists of proof and circumstantial evidence which are set out in the annex to the present regulation. And then under 2, whatever the criteria and provisions that are relied on, the requested member state shall, within the time allowed, check exhaustively and objectively on the basis of all information directly or indirectly available to it, whether its responsibility for examining the application for asylum is established. If the checks reveal that it is responsible under at least one of the criteria, it shall acknowledge its responsibility. That's probably self-evident, most of it, from the body of the regulation, but it does emphasise the importance of making checks when you've received the request. Article 5 then goes on to deal with what happens if there's a negative reply, where, after checks are carried out, the requested member state considers that the evidence submitted doesn't establish its responsibility. The negative reply it sends to the requesting state shall state full and detailed reasons for its refusal, as I said a moment ago. And where the requesting member state feels the refusal is based on a misappraisal or has more evidence it wants to put forward, it can ask for re-examination. It's got to be done within 3 weeks following the negative reply, and then the further reply from the requested state should endeavour to reply within 2 weeks. But that's all got to be done within the time limits in the substantive body of the main regulation. Article 12 deals with unaccompanied minors. Rather than my paraphrasing it, could I just invite you to read the whole text of that? So within Article 12, the time limits won't necessarily prevent the continuation of the investigations. The upper tribunals recently held that that should only be applied in, I think there's an exceptional or compelling circumstances where the best interests of the minor require it, because of course delay is antithetical to the interests of children as well. But there is that possibility for investigations and indeed negotiation between the two states to continue. And one would hope that in most circumstances it can be dealt with that way. What it doesn't do is impact on the construction of a transfer decision for the purposes of Articles 26 or 27. Then at tab 3,
I'm sorry, just before we leave tab 2, in terms of the evidence that's listed in Annex 2, that refers to means of proof, of which I don't think there's any in this case. But it also distinguishes between the process of determining the state responsible for examining an application for asylum from the obligation on the member state responsible for examining the application to take back, to admit or take back, and again in list B, which is circumstantial evidence, again it makes that distinction. Does this help us in identifying who is responsible for what, i.e. what the requested state is particularly responsible for, and what the requesting state is particularly responsible for, in terms of evidence or not?
I didn't think it did, and I'd been looking at the lists in the current implementing regulation, because there's
Yes.
correspondent lists at tab 3 in the 2014 implementing regulation. They're broadly similar.
Yes.
I didn't read them as helping decide who ought to do what, but I will look at them again over the short adjournment and check.
In terms of getting evidence,
Yes.
that's what I was thinking.
Yeah.
Whether it helps, it may not.
No, I didn't think it did, but of course I'll look at it again.
Yes.
I mean, what's quite plain from various recitals and substantive bits of the regulations is that Dublin envisages and expects that there should be cooperation between the two states and that they should be exchanging information, keeping each other informed. So the bits of the amending regulation, the 2014 regulation, at tab 3 I was going to take you to, were the additions to Article 12, which are, if you, not the first page, but if you turn over one page, on the right hand side you'll see 7. In Article 12 the following paragraphs are added. And that provides quite detailed provision in line with the principle I was just referring to about exchanging information. Again, I'm so sorry, I'm running out of voice. Could I ask you to read the additions to Article 12 rather than my attempt to summarise them?
This is Article 12 of Dublin 3, is it?
No, sorry, it's Article 12 of the implementing regulation,
Oh, I see.
from the first one at tab 2. So Article 12, as you may recall, we looked at a moment ago, relaxes the time limits, and then the second implementing regulation, the 2014 implementing regulation, added lots of provisions about cooperation and information sharing.
In a jurisdiction where you can take DNA, and it's got exchange of information, etc., under these provisions, do you say that would extend to that?
Yeah, well,
Or not?
I'm sure it would. And if it helps, again, we're not going to give evidence, but those instructing me have been continuing to explore and probe the possibilities for its transmission of DNA evidence between France and the UK. quite plain. It's not an issue that directly arises in this case, because obviously there wasn't permission to appeal on that ground. I'm not trying to go behind it, just so that you know. It seemed to us that it was difficult to see why, given that you can just get DNA from a mouth swab, which is what has been done in this case now that MS is here, why that could not just be done by the person themselves, and whether it would be prohibited under French law to then send that by courier here so it could be tested. So there are various options like that are being looked at, because although it wouldn't eliminate disputes like this, because DNA evidence certainly won't always be conclusive. Indeed, in sort of cases of wider family members, uncles and nieces or nephews and aunts, it's unlikely to be conclusive. And in the case of partners or spouses, it's really not going to help at all. But in some cases, in the children cases, it really could help. So it's not something that's not being progressed with, by the Secretary of State, because obviously that would be the ideal. But of course, you can't oblige people to provide DNA evidence, but to have some workable system where if somebody volunteered that they would like to do a DNA test, it would be good if that could be accomplished.
Well, the refusal of the DNA test may indicate the opposite.
Indeed, yeah. So, that's the implementing regulations. I'd suggested that maybe Dublin 4, the proposal for Dublin 4, could go at the beginning of the small bundle that my learned friends provided this morning. I don't know if you've got...
Hold, but we can do that.
Oh, I'm so sorry.
Yes.
So the document starts with the explanatory memorandum. And
Can I just have your headlines as to why we're looking at this?
well, because I was being asked about policy decisions, whether it was a policy decision to simply focus on, was there anything outside the regulation that showed there was a policy decision to limit remedies to cases where there was a transfer rather than no transfer cases. And I haven't got anything on that, although we'll look at the explanatory memorandum for Dublin 3. What we do have is the explanatory memorandum for Dublin 4, which does show a policy decision to introduce what's described as a new remedy in non-transfer cases, from which I say at very least some weight can be attached to.
And is there any difference in the way in which we should approach this from the way we would approach domestic legislation? In a domestic scenario, this may not be of much help. May not be of much help here. But are the approaches the same? Is the approach the same?
I think the approaches aren't identical because you're dealing with an EU regulation which is necessarily the consequence of a certain amount of negotiation between the member states, and where there is, as we know, quite an extensive process of consultation and discussion about what would be acceptable before something's laid before the Parliament, hopefully for acceptance. I'm not suggesting this is determinative in any way, but I'm saying it's consistent with our analysis, which is that you've had a progress from no remedies at all on individuals to remedies limited to the situation where somebody is being I was going to say threatened, that's the wrong word, but somebody faces transfer or removal from the country where they are currently, to a proposal for a new remedy, which is in some ways more restrictive, but in other ways more generous. And the more generous aspect is a new remedy limited to family cases where there's a decision not to transfer. So I'll just take you to it. I wasn't proposing to make long submissions about it, and I say it's something to which you can attach some weight. So, page 17, bullet point 3. It's only...
13.
sorry, 17,
17.
bullet point 3.
Yes.
And it's the last sentence of that.
And can we, where is it?
It's page 61. The current Article 27 under this proposal, 60 to 61, the current 27 starts at the bottom of page 60 of the document, and 27 is crossed out and becomes Article 28. Does my Lord have it?
Right.
Yeah.
So what is this? So this, what we've got here is the old Dublin III showing the amendments. Is that
Showing
it?
the Commission's proposed amendments.
Commission's proposal
Yeah.
amendments.
And you don't need to worry, I don't think, about 1, 2 and 3.
Well, hold a minute. One is relevant because it's there. Your submission is that if new 28.1, old 27.1
Yeah.
meant what Ms Kilroy says it means, 28.5 would not be needed. It would be OTOs.
Exactly.
So you've got to look at...
All right, sorry.
So
Yeah.
I know it hasn't changed, but the fact that it hasn't changed
Is important. I'm sorry, my Lord is absolutely right, of course. So 28.1 remains as it is, apart from the renumbering. Time limits are tightened in 2. So exercising the remedy no longer a reasonable period of time but 7 days. By 3, an appeal or review under Article 27 is to be decided within 15 days. But the suspensive effect is automatic, so no transfer shall take place before this decision is taken. Articles 28, 4 and 5 are the new provisions. 4 narrows the scope of the remedy. In a challenge to transfer. And effectively takes it back to the position as it was in Abdullahi under Dublin II, that you can't challenge the application of the criteria anymore. It's an assessment of conditions in the state to which you're to be transferred. But it adds at 5 a right of effective remedy where no transfer decision referred to in paragraph 1 is taken in family cases.
It's a bit difficult, isn't it? Because once you've taken out your ability to challenge the application of the criteria, and the only thing you can challenge on is risk of inhuman or degrading treatment, the scope for interpreting the old 27.1 as including this family member has gone. anyway.
That's quite right.
So that's the trouble when you've got a document that's being negotiated. It's not as simple as that.
No.
You're right in saying that this is the first reference to no transfer decision, but it's slightly confusing text, because are we supposed to say that in the case, I don't know, I'd have to think that through.
I think
it's
maybe
not straightforward.
No. Maybe the best point I can make for my purposes in reliance on this links back to the plain words. Okay, so if Dublin III had been intended to provide a remedy in no transfer cases, it could so easily have said so. It could so easily have just included a provision like this. The drafters and the states that negotiated it chose to introduce a remedy by reference to a transfer decision. Why do that if they intended to include the rejection of a take charge or take back request? You need to refer to transfer decision, and they could so easily have clarified by giving a right where there wasn't.
Well, I understand that one, it's clear enough, but I'm slightly doubting, and I have to think it through, but I'm slightly doubting the weight that you can place on 28.5, because there was in theory, subject to your overriding point, in theory you can fit in a no remedy case, in theory, subject to all your points, under 27.1, because you're entitled to examine the criteria whether they've been observed or not. Whereas once you said under 28, the revised 28.4, that any challenge can only be limited to inhuman or degrading treatment, that excludes all the family criteria. And they're all going to be, the challenges are going to be in a no transfer case. So what you're really doing here is it might be said against you, I'm not saying this is correct, I'm just trying to think it through, but it might be said in theory against you, well, they had to put in 25.3 this time, 28.3.5 this time, because that was the only way they could still carry over the family considerations, which are going to be in a no transfer case.
Yeah.
So I'm just not sure how far it takes you.
Well,
I see your point.
I think one's got to distinguish, and we'll see this when we come to the CJEU case law, between what you have got a remedy against, what sort of decision you can appeal or review, and the scope of that. So...
Yeah, you could just say I'm trying to be too clever.
No, not at all. Maybe I'm trying to be too clever. So there's a difference, isn't there, between what you can appeal and the grounds of appeal that you can run. Yes. Yeah. So Article 4 is dealing with the scope of the remedy laid down in Article 1. Article 5 is giving a different remedy. It's not adding to the scope. If they'd wanted to add to the scope, they could have had 4. The scope of the effective remedy laid down in paragraph 1 shall A, be limited to an assessment, save in cases concerning, etc., etc. Okay? What it's doing is giving a different remedy.
This is the trouble you started. Now we're now interpreting a different directive.
I'm saying this because, oh dear, I'm so sorry, I've overrun. When we come to the CJEU case law, which we will this afternoon, you'll see that they're very clear about the scope of the arguments you can run in an appeal or review. But there's a distinction between that and what the decision is that you can challenge. I'm so sorry to be...
No, that's fine. So we will. I know we've interrupted you a very great deal, but it's been helpful to us. How are you doing in terms of time?
I hope I'll be finished by 3 o'clock. I think we've got a day and a half set aside. I'll do my best to be. I mean, this was the longest.
Only if we need to go to a day and a half. That's not an encouragement.
Well, of course, it might be you don't need to call on my learned friend at all, which I'm sure would be a great disappointment to her, because she'll have lots to say. I will try and make it shorter. I think we've covered the bulk of my submissions.
2:05. Thank you.
Well, guys.